Let's start. As you are aware, before the Constitution, we had the Federal Court as the highest court in India. Of course, subject to the Privy Council. Then, when the Constitution was framed and when it was inaugurated, provision was made in Article 124 that there shall be a Supreme Court of India. As you are aware, in Schedule 2, Part D, some provisions were made regarding the salaries to be paid to the Supreme Court Chief Justice and other judges of the Supreme Court in respect of certain matters, as for example, leave, pension and certain other matters. Provision was made in Article 125 para. This is the position that was created under the Constitution. Now about 8 years have elapsed and a considerable amount of experience has been gathered. It is considered desirable that in respect of certain aspects of this question, namely leave of absence, pension, and certain other conditions of service, we should have a law made by Parliament. That is the reason why this bill has been placed before this Honorable House. In respect of all these three subjects, I should briefly point out that the present position is under the Constitution and the need that has arisen for making some changes in the schedule. It has been pointed out that leave can be granted to a judge of the Supreme Court on medical certificate for a maximum period of 6 months, and while he is on such leave, his pay or his allowances would be rupees 990 per mensem. Then he can also go on leave otherwise than on medical certificate. There also the total period was specified as 6 months, and he would be entitled to get the same leave allowance, namely rupees 900 per mensem. There might arise certain other circumstances when he would have to go on leave otherwise than under the two categories of leave which have been referred to by me just now. Technically, it is called for the sake of convenience as extraordinary leave. In the case of extraordinary leave, which a judge of the Supreme Court can take, a condition has been laid down that the total amount of which leave shall not exceed 6 months. In this particular case, in as much as he is going in the leave, he will not be entitled to any leave allowance at all. Stop para. When we are discussing the Planning Commission, it is proper that this demarcation should be kept in view as to what the Planning Commission stands for and can bear responsibility. Stop para. There were two main suggestions as to what the Planning Commission should do. One was that since the Planning Commission has formulated the plan or proposed the lines on which it should be reappraised, it should extend its responsibilities to the extent of ensuring that the policies recommended by it are properly implemented. This goes far beyond the legitimate functions of the Planning Commission. Ours is a federal constitution, and the powers of the union and the states are clearly laid down. There are various governmental and other non-official agencies to execute the plan. They must accept responsibility for these parts of the plan which concern them. The Planning Commission does not possess the necessary machinery for the execution of the plan. However, it does keep a watch and makes an assessment and recommendations on important matters from time to time. But that is all that it can do. But there is also another suggestion made by some members about the revision of cost estimates in the case of several projects. It was suggested that the Planning Commission itself should see to it that the cost estimates are kept within proper bounds and do not increase beyond a point. Here also, I would request the House to appreciate that it is not practicable for the Planning Commission to equip itself with a large body of technical experts. The main technical experts must be in the central ministers and the states. The Planning Commission has a relatively small staff. It has made some arrangements for technical scrutiny of irrigation and power projects, but for various schemes in the field of industry, minerals, development and transport, the Planning Commission depends on the technical personnel of the ministries and the arrangements which the ministries themselves make for further technical examination. Even the ministers are not self-sufficient in this respect and often have to rely on their consultants, who in a number of cases come from abroad. There are various limitations. The experts give a certain estimate and then later on the estimates are revised for various reasons. May be that after a fuller examination certain other material and facts are revealed which necessitate a revision. In many cases, the upward revision in costs has been due to an increase in prices of machinery and equipment, especially those imported from outside, which has occurred during the past 2 years. In some cases, the rise in prices is also due to some other factors. Stop. Thank you. Jai Hind. Jai Mera Bharat.